Her disciplinary file was sealed. Then it wasn't. And what the official records inside that unsealed document reveal about Mackenzie Sherilla's behavior at the Ohio Reformatory for Women is something her supporters online were not prepared to see. 36 conduct reports, 32 guilty findings, and a 60-day ban on video visitation that came directly from a moment she could never take back. The state's own internal logs tell a story that is impossible to ignore. And today, we are walking through every documented detail from the beginning. If this kind of deep, evidence-based true crime coverage is what you come here for, take 5 seconds right now and subscribe to Midnight Evidence and hit that like button. We go where the documents lead, and we never stop until the full picture is on the table. To understand what is happening inside that reformatory right now, we have to go back to where this story actually begins. Not in a courtroom, not in a prison cell block, but on a quiet July morning in 2022 in Strongsville, Ohio, inside a business park on Pearl Road, where 2 young men lost their lives in a matter of seconds. Dominic Russo was 20 years old. Davon Flanagan was 19. Both of them were passengers in a 2018 Toyota Camry being driven by Mackenzie Sherilla. They had their whole futures ahead of them. Families who loved them deeply. Friends who counted on them. And in a single catastrophic moment before sunrise, every possibility they ever had was permanently erased. That is the foundation of this entire story. Before we talk about prison violations, unsealed files, or revoked privileges, we owe it to Dominic and Davon to say their names and remember exactly what was lost on that road. The car did not slow down. It did not swerve in a panic. It accelerated. According to the event data recorder retrieved from the vehicle by investigators, the Toyota Camry was traveling at 92 miles per hour through a zone with a posted speed limit of 25 miles per hour. That alone would be enough to make anyone stop breathing for a second. But what the black box data also showed made the case for prosecutors even more devastating. The accelerator pedal was pressed all the way down, 100% full throttle, and it stayed there for 5 full seconds before the car slammed directly into a brick building inside that business park. 5 seconds. At 92 miles per hour, with 2 passengers in the car. Investigators also pointed to something else in their testimony that became one of the most critical pieces of the prosecution's argument. The road leading to the point of impact had a curve, and the data showed the vehicle had navigated that curve before striking the wall. Prosecutors argued in court that only a conscious, awake driver could have guided a car through a curve at those extreme speeds. That detail became central to the state's case, that this was not an accident. The defense told a completely different story. Shirilla's attorneys argued that she suffered from an undiagnosed medical condition that caused her to black out behind the wheel. They told the court she had absolutely no memory of the moments leading up to the crash, and that this was a horrific, unimaginable tragedy, not an intentional act. They asked the court to see a young woman who had lost control through no fault of her own. But Cuyahoga County Judge Nancy Margaret Russo, presiding over a bench trial, reviewed the evidence presented by both sides and reached her conclusion. In August of 2023, the judge found Mackenzie Sherilla guilty of 2 counts of murder and 2 counts of felonious assault. The court stated that the evidence demonstrated she had made a conscious choice that morning. Shirilla was sentenced to 2 concurrent terms of 15 years to life in prison. She was 19 years old when that sentence came down. That verdict sent shockwaves through the public. The case had already attracted intense national attention, and the sentencing only amplified the debate. On one side, people pointed to the black box data and argued justice had been served for Dominic and Davon. On the other side, advocates, including Shirilla's own mother Tina, maintained publicly that her daughter was wrongfully convicted, and that the truth had not come out in that courtroom. Tina Shirilla became a consistent and visible voice on social media, continuing to argue her daughter's innocence long after the gavel came down. And that public campaign from her mother is one of the reasons the contrast with the official prison records is so striking. Because while the narrative outside the reformatory walls painted a picture of a misunderstood young woman enduring a harsh and unjust sentence, the documents coming out of the Ohio Department of Rehabilitation and Correction told a fundamentally different story about what was happening on the inside. The unsealed disciplinary file from the Ohio Reformatory for Women is not a document you can dismiss. 36 total conduct reports filed against Shirilla within her first years of incarceration. Out of those 36, the official logs recorded guilty findings on 32 of them. 32. That is not a pattern of a young woman quietly enduring her circumstances. That is a documented record of consistent, repeated institutional rule-breaking that goes far beyond what anyone following this case online had been told. When you are serving 15 years to life, your conduct record inside the facility is the only currency you have. Every privilege you hold, whether that is access to a tablet, the ability to make video calls, the right to purchase items from commissary, or simply the ability to maintain some connection to the world outside those walls, all of it is contingent on following the rules. For an inmate who will one day stand before a parole board and ask to be released, that conduct file is the most important document in the building. And Shirilla's file was filling up fast. The violation that directly triggered the most significant consequence in recent months is the one that resulted in a 60-day suspension of her video visitation privileges. According to the official conduct records, Shirilla pleaded guilty to a Class II institutional rule violation involving explicit conduct on a monitored video call. The documentation states that she exposed herself during a video session with an outside visitor who was fully undressed and using adult toys on the other end of the screen. Prison staff monitoring the call shut it down immediately. The result was a strict 60-day ban on all video visitation access. To appreciate why the prison responded as severely as it did, you have to understand what the video visitation system is designed for, and what it is absolutely not designed for. In most state correctional facilities, inmates are granted access to tablets or designated kiosks where they can make video calls to pre-approved contacts, usually family members or close friends. It is a structured, monitored privilege, not a right. The calls are recorded. Guards actively monitor them. And the rules governing those calls are explicit and non-negotiable. Sexual conduct of any kind is strictly prohibited, not as an arbitrary restriction, but as a documented security measure. In an environment where hundreds of inmates live in close quarters, allowing explicit material to be broadcast on shared institutional devices creates cascading risks. It can fuel extortion. It can trigger confrontations. It can compromise the safety of both inmates and staff. When guards documented what was happening on that call, the institutional response was immediate and by the book. But the video call violation, as serious as it was, represented only one layer of what the unsealed file contained. The conduct reports also documented the results of physical cell searches conducted inside her housing unit. Prison shakedowns are not minor inconveniences. They are exhaustive, unannounced, and deliberately thorough. Guards enter a cell block without warning and systematically search every inch of every cell. Mattresses are flipped. Personal storage is emptied completely. The bindings of books are checked. Nothing is left unexamined. What those searches turned up in Shirilla's case created a documented picture of someone consistently attempting to operate outside the boundaries of institutional rules. The official facility logs recorded that guards found altered state-issued clothing during at least one of those searches. In a maximum security reformatory, uniformity is not about aesthetics. It is about control and identification. When an inmate modifies state-issued clothing, it is treated as a direct challenge to institutional authority, and it is logged accordingly. The searches also turned up unauthorized arts and crafts supplies, specifically items including glitter and paint, as well as stolen charms. It is easy to hear those words and assume they are trivial. But inside a corrections facility, unauthorized items of any kind represent a breach of the system designed to track and account for every object in an inmate's possession. If contraband as seemingly minor as craft supplies can move through a cell block undetected, it signals a much larger vulnerability in the security perimeter. And that reality is taken seriously by administrators, regardless of what the items actually are. Then, there is the finding that carries the most serious weight of everything documented in that file. According to the official conduct records, a shakedown of Shirilla's area also revealed that she was in possession of another inmate's prescription medication. Prescription pills in a correctional setting are one of the most tightly controlled and dangerous commodities that exist within those walls. The black market for medication inside a prison is real, active, and deeply dangerous. Possessing another inmate's medication means involvement in a chain of transactions that can lead to overdoses, violent disputes over supply, and serious harm to everyone in that housing unit. The logs do not detail precisely how the medication came to be in her possession. What they document is that it was there, and that is where we have to stop for a moment. Because while we are walking through these conduct reports and discussing institutional violations, two families in Ohio are living every single day inside a grief that has no exit. Dominic Russo was 20 years old. Davon Flanagan was 19. Their families are not debating prison privileges or reading unsealed disciplinary files. They are carrying the permanent weight of losing their sons. Every headline about Mackenzie Sherilla's conduct violations is another reminder for those families that the person held responsible for those deaths is still making news, still creating chaos, still taking up space in a world that Dominic and Davon no longer get to inhabit. That reality has to stay at the center of how we think about this entire story. Because the prison logs matter, the violations matter, the revoked privileges matter, but none of it exists in a vacuum. It all exists in the shadow of July 31st, 2022, and the two lives that were taken on that road in Strongsville. There is still more in this file that we have not covered yet. The full picture of what the Ohio Department of Rehabilitation and Correction has documented goes deeper, and the implications for her future inside that reformatory are significant. If you want to follow this story all the way through, subscribe to Midnight Evidence right now, and make sure you like this video so more people can find it. We are just getting started. You will not want to miss. The contraband findings were serious enough on their own. The prescription medication, the altered clothing, the unauthorized supplies found during unannounced searches of her cell. Those violations alone would have been enough to define a troubled institutional record. But the unsealed disciplinary file from the Ohio Reformatory for Women does not stop there. Because layered on top of everything recovered during those shakedowns is a separate and equally documented pattern of direct, scheduled defiance against the most fundamental routines that keep a correctional facility functioning. According to the official conduct logs, guards recorded multiple instances of Shirilla being out of place during mandatory cell counts. If you have never spent time inside a correctional facility or studied how they operate, you might not immediately understand why that particular violation carries so much institutional weight. But the count is not a formality. It is the single most critical procedure that happens inside any prison, every single day, multiple times a day. Every officer on duty must physically account for every living person inside that facility. The numbers have to match exactly. If one inmate is out of place, if the count does not clear, the entire facility can be placed on immediate lockdown. Every other inmate in that block stops moving. Every scheduled activity halts. Every person inside those walls pays the price for one person's failure to be where they are supposed to be. It creates immediate tension with the guard staff, and it punishes the entire population of that housing unit. That is not a minor administrative hiccup. That is a documented disruption to the operational security of the entire facility. The logs also record instances of refusal to follow direct orders related to basic housing unit cleanliness and general facility regulations. Refusing to maintain her assigned area. Refusing to position herself exactly where officers instructed. These are not dramatic acts of rebellion. They are quiet, grinding, daily refusals that accumulate into a documented pattern of resistance against basic institutional authority. When you place those cold official records directly beside the public image being maintained by her family online, the disconnect is impossible to ignore. Her mother, Tina, has remained a consistent and vocal presence on social media, continuing to argue that her daughter is simply trying to survive a harsh and unjust environment. And as a parent, that instinct is completely understandable. The desire to protect your child, to explain away the things that make them look bad, to believe the version of them that you know from home rather than the version being documented in a state file. That is a human response. No reasonable person watching this can fail to understand where that impulse comes from. But the Ohio Department of Rehabilitation and Correction does not log 36 conduct reports by accident. Guards are not writing up formal disciplinary findings out of personal animosity toward a high-profile inmate. These are official state documents, reviewed and processed through an institutional system that requires evidence and formal procedure before a guilty finding is recorded. The records exist because the behavior they document occurred. And the gap between the story being told online and the story being told inside that facility is documented, verifiable, and growing wider with every new entry in that file. To understand what may be driving this consistent pattern of rule-breaking, we have to look at something that came directly from Shirilla herself. Media outlets obtained recordings of monitored phone calls between Shirilla and her family members. These are not second-hand accounts or interpretations. They are her own words, captured on the same institutional system that recorded the video call violation. And what those calls reveal about her psychological state inside the reformatory is deeply telling. In those recorded conversations, Shirilla expressed severe and ongoing desperation about the boredom of life inside her cell. This was not casual venting or mild frustration. The tone documented in reports covering those calls described something closer to a deep psychological weight pressing down on her daily existence. In one specific call, she stated that she did not even know how to make a book stretch because there was simply nothing to do inside the facility. Sit with that statement for a moment. Making a book stretch. When you are facing a sentence of 15 years to life, time is no longer measured in days or weeks or months. It stretches out in front of you like a landscape with no visible end. The walls do not change. The routine does not change. The concrete does not change. And for a young person who entered that facility as a teenager, the psychological reality of confronting that kind of permanence is something most people will never have to experience. The boredom she described in those calls appears to be a genuine and documented psychological reality of her incarceration, not a manufactured complaint. But understanding the cause of her behavior does not remove the documented consequences of it. The Ohio Department of Rehabilitation and Correction responded to her pattern of violations and the downtime that appeared to fuel them with a structured institutional countermeasure. Under Ohio correctional policy, able-bodied inmates serving life sentences are required to work. The facility officially assigned Shirilla to a mandatory position as a food service worker in the prison kitchen. For that daily labor, the standard maximum inmate wage documented by the facility is up to $24 per month. $24. For waking before dawn. For working in a loud, industrial kitchen environment. For serving meals to hundreds of fellow inmates. And cleaning heavy equipment at the end of every shift. That figure is not meant to be comfortable. It is not designed to replicate the outside world in any meaningful way. It is a structured reality check built into the institutional framework, and it serves a very deliberate purpose. The administration's logic is straightforward and entirely consistent with established correctional practice. An inmate who has demonstrated a pattern of filling unstructured time with rule violations needs that unstructured time filled by something else. The kitchen assignment does exactly that. It forces direct interaction with the broader prison population, under constant supervision. It places her under the daily authority of food service staff who report directly to institutional leadership. And physically, it is exhausting work. A person who has spent the day on their feet in a prison kitchen is considerably less likely to spend the evening attempting to hide contraband or misuse a monitored tablet. Whether this assignment will successfully break the documented cycle of defiance remains an open question. But the administration has made its position clear. The structure she refused to accept voluntarily will now be imposed through mandatory labor. While all of this was unfolding inside the facility, a separate and equally significant development was taking place in the legal system outside those walls. Shirilla's defense team had been working to secure her a new trial through the appeals process. They argued that the original proceedings were flawed and that she deserved the opportunity to have her case reviewed. The Ohio Supreme Court received that appeal and examined the procedural record surrounding it. The court rejected the appeal entirely, and the stated reason behind that rejection is something that is genuinely difficult to process no matter which side of this case you stand on. According to the legal record, her defense attorneys missed the mandatory statutory filing deadline by exactly 1 day. The applicable law required the appeal to be filed within 365 days. Because the relevant period included a leap year, which added a 29th day to February, the actual deadline fell 1 day earlier than her attorneys had calculated. The filing arrived on what was technically the 366th day. The Ohio Supreme Court held that the law means what it says, and that filing deadlines are not subject to discretionary extension. The appeal was dismissed. Her legal path to a new trial is now permanently closed. 1 day, one calendar miscalculation involving a leap year. That is the margin by which her final legal option disappeared. There are people who will look at that outcome and argue that justice was undermined by a technicality. There are others who will argue that procedural rules exist for a reason, and that courts cannot selectively enforce deadlines based on sympathy. Both of those conversations are understandable. But before we spend too long debating leap years and filing windows, we have to return to the place this story always needs to return to. The families of Dominic Russo and Davon Flanagan do not have an appeals process. They do not have a statutory deadline they can miss and try again. Dominic was 20 years old. Davon was 19. Their families have been marking the anniversaries of July 31st, 2022, without the ability to file anything with any court that will bring their sons back. While attorneys were calculating calendar days and reviewing procedural rules, those families were sitting with a permanence that no legal system can address. The loss they carry has no filing deadline. It does not expire. And every time this case generates a new headline, whether about prison violations or dismissed appeals, they are pulled back into the center of a story they never chose to be part of. That reality has to carry more weight in this conversation than any procedural outcome ever could. With her appeals now permanently exhausted, the full weight of her sentence has settled into place in a way it perhaps had not before. And that reality connects directly to the documented damage her conduct file is doing to her long-term future inside that system. When you are serving 15 years to life in Ohio, your disciplinary record does not reset. It does not fade. It does not get sealed away from the people who will one day decide whether you ever leave. Every one of those 32 guilty findings is a permanent entry in the file that will be opened in front of a parole board. Her first parole eligibility date falls in October of 2037. She will be in her early 30s. She will sit across from a panel whose job is to determine whether she is safe to return to society. That panel will have access to everything: the event data recorder evidence from the crash, the judge's stated finding that she made a conscious choice, and every single documented conduct violation from her years inside the Ohio Reformatory for Women. The board will see the explicit video call. They will see the prescription medication found in her possession. They will see the altered clothing, the unauthorized supplies, the missed cell counts, the refused direct orders. All of it in one file, all of it permanent. That is the concrete, documented consequence of the behavioral pattern we have been walking through today. Not just lost tablet access or a 60-day video ban, though those losses matter. The real consequence is the record being built right now, one guilty finding at a time, that will be the primary evidence against her when she finally has the opportunity to ask for her freedom. The questions this case raises are ones that do not have easy answers. Is the volume of violations evidence of a person who fundamentally refuses to accept accountability, consistent with the court's finding that she made a deliberate choice on that July morning? Or is it evidence of a young mind fracturing under the psychological pressure of a life sentence, acting out because the weight of permanent incarceration is producing a kind of institutional breakdown? When she said in her own recorded words that she did not know how to make a book stretch, was that a window into genuine psychological suffering, or was it the same disregard for consequence that prosecutors argued put that accelerator to the floor? The debate about whether correctional facilities should provide more structured programming and educational opportunities for young lifers to reduce conduct violations is a legitimate policy conversation. So is the question of how heavily a parole board should weigh early institutional behavior when evaluating an inmate's readiness for release, more than a decade after those violations occurred. These are real questions that go beyond this single case and touch the broader reality of how this country handles incarceration for young people serving life sentences. But at the center of all of it, underneath every documented violation, and every dismissed appeal, and every administrative consequence, are two names that deserve to anchor every part of this conversation. Dominic Russo, Davon Flanagan, 20 years old and 19 years old. Gone on a July morning in Strongsville, Ohio. Their families are living with a sentence of their own, one with no parole eligibility date, no appeal window, and no end. The courtroom cameras are gone. The legal proceedings are finished. The privileges inside that reformatory are being stripped away one by one. And the only question that matters in the long run is whether any of this, the violations, the consequences, the collapsed appeals, the mandatory kitchen shifts, will ever come close to accounting for what was permanently taken from those two young men and the people who loved them. That is where this story lives. Not in the disciplinary file, not in a calendar miscalculation, but in the irreversible weight of what happened on that road, and the two families still carrying it every single day. If you stayed with us through this entire story, it means you care about getting the full picture, not just the headlines. Subscribe to Midnight Evidence right now and hit the like button so this coverage reaches the people who need to see it. We will keep following this case and every case like it, because the truth deserves to be told completely, and the people at the center of these stories deserve to be remembered.